state your name for the record?
Slim Sooner.
Could you spell your first and last name?
Slimsunner.
Thank you. You may be seated.
Good morning, Doctor.
Good morning.
I'd like to start with a little bit about your background, if I could. Could you begin by telling us what your educational background is?
I went to Brown University as an undergraduate, continued on to graduate school and medical school. I did my residency at Rhode Island Hospital in emergency medicine, and I work at Rhode Island Hospital.
And you have the degree medical doctor?
I do.
Are you a licensed physician in the state of Rhode Island?
I am.
And do you specialize in any particular area?
I specialize in emergency medicine
Where do you work presently?
at Rhode Island Hospital.
Would that be in the emergency department?
That's correct.
What role do you hold in that department?
I am an attending emergency physician. I also am the director of disaster medicine and emergency preparedness.
How long have you been at Brown Hospital in the emergency department?
27 years.
And with respect to any board certifications, do you hold them in emergency medicine?
I do. I'm board certified in emergency medicine.
I'd like to turn your attention, if I could, to June 23rd, 2021. Were you on duty in the emergency department that night?
I was.
Did you have occasion to offer treatment or participate in the treatment of one Dominic Vincent?
I did.
Can you tell us how he presented to your emergency department?
I can. He was brought in by an ambulance with injuries to his arm. He told us that he was shot with a gun. We observed injuries to the arm, which he had deformity to the arm and 2 large wounds to the arm.
When you say 2 large wounds to the arm, could you elaborate a little bit on that, Doctor?
I can. There was one wound to the posterior, to the back of the upper arm, which was quite large, and a second one that was further down the arm on the opposite side in the front of the arm.
Were any x-ray studies made of Mr. Vincent?
Yes, x-rays were obtained of that extremity.
Stage 15 is on display and in focus, Doctor. Could you describe what we're seeing in these images?
Sure, these are 2 x-ray images of the left upper extremity. In the left image on the top, you can see the shoulder joint, which is rounded and sits in a cup. Further down, part of the humerus bone, which is the bone in the upper arm, is seen, and it is obviously broken and deformed. There is some soft tissue swelling, meaning swelling of the tissues of the arm. There's also metallic fragments seen in this image. And the image on the right is of the same upper extremity, just a different view of that. The X-ray was taken from a different angle.
Placing state 16 on screen. Could you describe this imaging for us, Doctor?
Again, this is an image of the left upper extremity, X-ray image, and not much different from the first image. The amount of deformity is a little less. This may have been because we repositioned the arm to reduce that deformity. You can also see two paper clips in this, and that's typically what we do to mark the areas of the wound on the skin.
With respect to the injury received to the humerus, do you describe it with any special nomenclature?
We could call that a deformed comminuted fracture of the humerus.
And you mentioned there were fragments in the arm, is that correct?
That's correct, there are metallic fragments.
Was a projectile recovered from the arm?
Correct. There was a metallic fragment that could be visualized in the wound that was on the front of the arm, and that projectile was removed.
And as of the patient's release from the hospital, did fragments remain in the arm?
Correct. You can see from this X-ray that there are many small metallic fragments. We typically do not search for them and pick them out of the wound unless we see them, and they remain in the wound.
Now, with respect to where you've marked with paper clips the injury to the skin, can you comment at all on the condition of the skin as it appeared during the course of treatment?
Certainly, there was a large wound in the back of the arm where soft tissues were visible, muscle was visible. The wound extended through the skin into the muscular tissue. There was a second wound in the front of the arm, which was smaller. We could see the skin was disrupted, but it was not as big as the wound in the back.
Were multiple courses of treatment considered during Mr. Vincent's stay at the hospital?
Yes, in the emergency department, our priority was to stabilize the patient. Initially in the ambulance, his blood pressure was low, so we were worried about significant bleeding or other injuries, so we examined him and did some studies to rule out other injuries. And once the injury was isolated to the upper extremity, we focused on cleaning the wound to prevent infection down the line. And we consulted our orthopedic surgery and trauma surgery colleagues to provide definitive care for this injury.
Was surgery indicated at that time?
It was not clear initially whether surgery would be indicated or not. We cleaned the wound extensively with pressure irrigation and removed dead tissue, and as well as the projectile that was visible. And then we splinted the extremity, admitted the patient to the hospital, and then he got further imaging in the hospital, and it was determined that closed reduction would be sufficient for the time being, and if the bones didn't come together well, then further surgery down the line would be considered.
You indicated that the arm was splinted, correct?
Correct.
Was there a special type of splint that was used in this case?
I think there was a coaptation splint that covered the area from the shoulder all the way down to the elbow.
Now, in your experience, in your training, would an injury such as this immobilize the arm for a long period of time?
It would. This is an injury not just to the bone, but also to the skin and muscle of the arm, and it would require long-term immobilization followed by a long rehabilitation phase.
And what about the injury to the skin, especially the injury on the back of the arm? Would that disfigurement be essentially permanent?
Yes, it would. There was a large skin defect, and as that heals, it forms a scar, and that scar would be permanent. If cosmetics are an issue, there could be revisions to the scar, but the scar would not go away completely.
May I have one moment?
Yes.
Doctor, with respect to the fragments that remain within Mr. Vincent's arm, is there a reason why they're not removed?
To remove them would require digging into the wound, maybe extending the wound with a surgical incision, and looking around in the tissues with instruments. This could disrupt the tissues, it could injure nerves, and we know from long history of leaving these fragments in, they usually do not cause further harm. So I think going after them would be more harm than leaving them in.
And just so it's clear, Doctor, you testified about a wound to the back of the arm, correct?
Correct.
Defect in the skin.
Correct.
And I know you don't classify exit and entrance wounds, but was there anything that could have been considered, in colloquial terms, an exit wound on the front of the arm?
It's very difficult to say because projectiles, once they enter the tissue, can change their trajectory. They can bounce around bone and other structures and wind up in different areas, but more than likely the wound where we saw the large projectile was probably the exit, and the other wound in the back was probably the entrance. But again, I'm not a forensic physician, but that would be my assessment.
And with respect to where the large projectile among the fragments wound up, it didn't actually come out until there was intervention of the hospital, correct?
That's correct. It was visible within the wound in the skin, and we removed it using forceps.
And were you in fact satisfied that the bullet itself, or the projectile that entered the arm of Donald Vincent, was the cause of that fracture?
Yes.
Nothing further.
Doctor, I really only had one question, but I think you just answered it. Once the bullet enters, it can break apart, it can hit structures in the body, and fragments can go in different directions, correct?
That's correct.
All right. Thank you, Doctor.
Thank you.
Your Honor, good morning and thank you. I have a motion under Rule 29 for a judgment of acquittal and or dismissal of count 4 of the complaint. That is the count alleges, which is 11-47-3.2, that statute. And the basis of my motion, Your Honor, I incorporate the arguments made in a supplement to my pretrial memorandum submitted on 12/22 of '22, and I just comment on some highlights at the moment. This motion is based on the gross disproportionality principle enunciated and adopted by our Supreme Court in McKinney v. State, 843 Atlantic 2nd, 463, State v. Montero, 924 Atlantic 2nd, 784. And it centers around the Eighth Amendment issue concerning the mandatory sentence that is attendant to 1147 3.2. And it speaks to whether or not the required sentence is grossly out of proportion to the severity of the alleged crime. Question is whether or not the sentence is commensurate with the gravity of the offense. Of course, we're premature at the moment, but I'm making this motion because the state is closed, and I think the court has a sufficient record to consider this motion. The sentence is disproportionate if it is unduly harsh when compared to the crime. Judge Krause gave probably a very good explanation of this principle in the matter of State v. Reyes, a Superior Court opinion of Judge Krause, which I attached to my pretrial memo. And he spoke about the intent behind that statute, the legislature's intent as enunciated by the Supreme Court in the McKinney and Montero cases. And referencing those cases, he said that the statute was designed to address the proliferation of gang violence and malicious rampant street shootings and the, quote, hoodlums associated therewith. In the Reyes matter, a soldier was on leave from the military, and while in the presence of his wife, he mishandled a firearm in a grossly negligent manner, such that he was convicted of manslaughter for the wife's death. Under the 1147 3.2, it would have been mandatory to issue him a mandatory life sentence, consecutive to whatever the other sentence would have been. And Judge Krause noted the legislative intent behind the statute, again as expressed in McKinney and Montero, and he ended up dismissing that count. He noted that it is more the rare exception, of course, but he dismissed it, noting that Reyes was not the type of hoodlum the statute was meant to address, nor were the circumstances of his crime the type of circumstances that statute was meant to address. This case, even of what we've seen of it so far, the state having rested, this case is similar to Reyes in that regard. It's certainly, I think the court would agree, an atypical ADW case. Defendant Dolan is neither the hoodlum or the gang member type of person engaged in a rampant street violence, again, that the statute was meant to address. And I think enough evidence has played itself out so far to show that the circumstances of the alleged offense are not the type of statute was intended to address. In effect, Your Honor, it would call for a mandatory 20-year consecutive sentence, should a conviction result. And that would certainly, under the guidelines of Reyes, Montero, and McKinney, that would certainly be grossly disproportionate and not commensurate with the gravity of the alleged offense.
You certainly raised a significant issue. Is it a Rule 29 issue, however, do you think? And, you know,
Well, ordinarily it would be Rule 12, but
Okay.
because we needed to wait, I mean, the very nature of this motion,
Because,
It
because,
couldn't-
the reason, and Rule 29 is based upon sufficiency of evidence generally.
Right.
And it strikes me, you're arguing evidence to a certain extent because you're using the evidence to substantiate your argument about disproportionality, but you're not really arguing that there is insufficient evidence to support the charge. You're just arguing that it's an inappropriate charge under the circumstances in this case.
that's correct, Your Honor.
Okay.
I just think, right, yes.
Okay. Thank you.
Thank you, Your Honor.
Your Honor, the state would oppose any Rule 29 motion at this time. The state has presented sufficient evidence and laid a very strong foundation for proof that is capable of generating guilt beyond a reasonable doubt. Specifically, the state points to the testimony of the several witnesses who saw this event: Dominic Vincent, Joseph Greco, as well as
Well,
Vincent.
Mr. Carter, I don't think it's an evidentiary question. I mean, it is to the extent that Mr. Colucci is using the evidence to support his disproportionality, but what he said is the thrust of his argument, which is a valid, certainly a valid argument in regards to his contention that it's overcharged by having this fourth count in there.
Well, I agree with Your Honor's observation that Rule 29 is not the correct vehicle to address this. However, to the extent that the court would like to hear argumentation on that point, I can suggest this. The Reyes case that Mr. Colucci cites is a trial-level decision. It construed the manslaughter charge, involuntary manslaughter, in conjunction with the consecutive life sentence that would have to follow upon that. And there was no room for the judge not to impose the life sentence. We are in a totally different context here. First and foremost, the using a firearm while committing a crime of violence statute and the way its sentencing is imposed has never been found to be unconstitutional by this Supreme Court in our state. That's point one. Point two, the configuration is completely different. It carries 20-year consecutive, but that is not automatically prison time. It can be suspended. The defendant hasn't even been convicted or found guilty of that charge yet, and the court has quite a bit of discretion in how it may configure any sentencing after the jury returns verdicts of guilty. So I think the argument fails. And the McKinney case, Lisa Montero, they do not stand for the proposition that it's unconstitutional. They just don't.
Thank you, Mr. Carter. Well, I was actually going to do the colloquy with the defendant, but I don't know if they what you wanted to address. What is it you wanted to address?
I just want to renew the motion on the Handy v. Geary, just so I'm not risking waiving it, you know how that works, Your Honor.
You're
So-
referring to the introduction of evidence about the six-pack in the back of the car.
And any evidence of consumption.
All right.
Now, if I may supplement the record on that point.
Yes.
When it came to defendant's statement, we redacted certain portions of his claim of having had anything to drink during his ride down to West Greenwich. What we put on the record were photographs of recovered physical evidence from the truck of Daniel Dolan. We stayed scrupulously clear from evidence of actual consumption, and that's why we agreed to redact that statement.
So the record is clear on that. The court's reasoning on allowing that evidence was not to allow it for any evidence of intoxication, but for evidence not only of recovery, but for, in essence, other evidence that might go to the defendant's state of mind. There's been testimony about the defendant observing what was going on in the roadway, being concerned about the actions of the victims, and the court sensed that it would be
that final thought, Your Honor.
Yeah.
Perhaps the parties can stipulate, because the state is well aware of the testing results that evening. Perhaps the parties can simply stipulate that
We can
was,
talk about that.
you know.
And we can discuss that further, okay?
Okay, can we just, perhaps we can discuss it now, it may take 30 seconds, but while
We're
we're at
actually,
recess.
we're gonna break, I'm gonna have you come to the chambers to talk just about scheduling, so we can discuss it then, okay?
Great.
All right. Dolan, as you've obviously heard in court, and I've previously been informed that you, expect to testify in this trial, is that correct?
Yes, Your Honor.
And I just wanted to talk about that with you, that's obviously your right to do so, but I just wanna make sure that, that we've discussed a few things. And first, without asking you about your discussions with your attorney, all I'm going to ask you is whether you've discussed that issue fully with your attorney.
Yes, Your Honor.
And he's answered all of your questions to your satisfaction.
Yes, Your Honor.
And you understand that you obviously have